I am actually having to give this presentation for Christopher Slogabin, and I was supposed to have a very easy job. I was supposed to be introduced to Christopher Slogabin. I was going to ask him, is that actually how you pronounce your name? Because I think I mispronounced it, perhaps, but I'm not too sure. But he was supposed to be the sage on the stage. So, unfortunately, weather didn't let him get his plane. So you'd have to do with me as kind of a guide on the side, where I'm going to try and guide you through some of these issues that we're going to look at for the next couple of minutes. I suppose the presentation that I have cobbled together very last minute is going to give some background to the issues, the legal issues, and then we're going to look at the insanity defence and diversion, unfitness to plead, and then look at the difficulties and the options for law reform. So how can we change the law in this area? Okay, so just to give you, I suppose, some background to this, is that the criminal law, the foundation of the criminal law, dates back hundreds of years, okay? And the rationale for determining criminal responsibility, it's very antiquated, it's quite discriminatory. And I have a reference here to a book by Andrew Ashworth. He's one of the leading criminal lawyers in the world. And he talks about the notion of criminal responsibility. And one of the fundamental presumptions in the common law in Ireland and in England and Wales, other common law jurisdictions, is that the offender is normal, okay? This is the rationale, that if you were to be criminally responsible, you're a normal person. And if there's any question around that in relation to a mental health problem or an intellectual disability, there is a belief in the common law that has developed over the years, over hundreds of years, that you shouldn't be held responsible if you're not rational for your actions. So you're absolved of your criminal responsibility. And this autonomy-based rationale is why many jurisdictions around the world have something like the insanity defence. So it's quite discriminatory. It's all these presumptions operate. And it's very much discriminatory, increasingly in light of the UN Convention on the Rights of Persons with Disability, these notions of being normal and accountable and rational, and that you're not rational if you're a person with a disability. And that might be connected somehow to the offence that you're alleged to have committed. Okay, so Article 12 is very important here. As we've heard today, I won't get into it in any more detail, that the notion is that we all have legal capacity, universal legal capacity to act, and that if there's a question around that, you give support and reasonable accommodation. Okay? So, what was interesting is that when this convention was concluded, the UN Convention on the Rights of Persons with Disabilities, nobody really thought that the notion of legal capacity in Article 12 was going to change the law in this area. And very early on, it was clear that it was going to have implications. And the quote up here, I won't read it out, it's from the, it was from the UN Office of the High Commissioner of Human Rights in 2007, where they indicated that the UN Disability Convention would have an impact in this area. Okay? They formed a more certain view in 2009, where they said, the Office of the High Commissioner for Human Rights said that you needed to abolish the insanity defence and replace it with something that isn't discriminatory, that has to be disability neutral. That's a very kind of simplistic outline. That's exactly what the UN Office of the High Commissioner for Human Rights said. Now, we come to the general comment. The first general comment. Does everybody know what a general comment is? No. So a general comment is something that a UN committee that's responsible for ensuring compliance with a convention use to kind of show state parties how they become compliant with the convention. And the first one that was issued, Eleanor and Anna were very centrally involved in it, was in Article 12. So that state parties know what legal capacity means, how they can change the law to comply with their obligations. And I have to say, reading Article 12, it isn't very clear. They don't actually specifically engage on the insanity defence. But there is this sense that the fact that you have an insanity defence, it's discriminatory, it goes against the UN Convention, and it is perhaps in violation of Article 12. Okay? So it'll be interesting to see how the UN committee based in Geneva develops its jurisprudence in relation to this. Okay. So to talk about the insanity defence then, the first thing I'd say is that the insanity defence is one of the most controversial defences in the criminal law. It's been criticised for decades in relation to how it operates. And in theory, if you're deemed not guilty by reason of insanity, you're absolved of criminal responsibility, and the theory is that you're not punished. But the reality is, if you raise the not guilty by reason of insanity defence, you're going to spend longer in lots of parts of the world in a forensic psychiatric hospital like the Central Mental Health Hospital in Dundrum. than you would if you were convicted and sentenced to prison. So there's a human rights issue here that flows from raising this defence that you're going to go to a forensic psychiatric hospital and you're at risk of actually being forcibly medicated and treated against your will. So there's a real risk of raising the insanity defence. The Law Commission in New Zealand looked at reforming the law here. They gave some very insightful comments in relation to this. So what they said was, actually, in operation, the insanity defence is very unprincipled. It doesn't actually deliver what it promises. And there's a lot of human rights issues that emerge. Okay? Now, what I will say in relation to the insanity defence is actually, it doesn't come up that often, really. One of the studies which would suggest that in all criminal cases, it only rises in 0.05% of cases, actually. So it doesn't actually rise that often. Okay? Now, the other issue is diversion. Okay? This is something that we haven't really developed very well in Ireland, but there's now an overrepresentation of people with mental health problems in our prison systems, certainly in Western Europe and North America and Australia. And that's linked to the deinstitutionalisation movement and the failure to develop mental health services. So what's happened in countries around the world is that they've developed a number of processes in the community during arrest, before trial, at the court and following conviction to divert people from the criminal justice system very often to mental health services. And there's a big question here around criminal responsibility because there's this assumption that it's good to transfer people, and the notion is that regardless of whether a mental health problem is connected to the offender or not, there is an assumption that we should connect people to health services. And that raises a lot of questions around forced treatment. For example, in mental health courts in North America and Canada and the US, very often coercive treatment for a mental health problem is part of participating in a mental health court programme. I won't get into much more detail on that now. Okay, psychiatrists are very critical of the general comment number 1, and one of the reasons they've criticised it in this journal called The Lancet is because of its call for moving away from diversion from the criminal justice system. Now, I don't agree with that, but we need to be aware that the psychiatrists are lining up against this interpretation of the UN Convention. Now, the other area I want to talk about is unfitness to plead, or fitness to plead, or competency to plead. Have you ever heard of these terms? Yeah, okay. These are provisions in the law that happen all around the world. And if somebody with an intellectual disability or mental health problem comes before the courts and there's a question about whether or not they can participate in their defence, if they're considered to be very ill or impaired, these very medical approaches, what happens is that you have a human rights violation. So what happens is that people are not allowed to stand trial, and people can be indefinitely detained, which is a significant human rights issue. And we've had that here in Ireland, where people have actually died in the Central Mental Health Hospital, where they have been never stood trial for their alleged offences, and they've never been able to gain their liberty. So the UN Committee has taken a very firm view of this in its jurisprudence and its guidelines in Article 14, which is the right to liberty, and they've said that you can't have these types of laws, that they are discriminatory. Okay? So there's a very significant issue in relation to that. So now we come to the issue of what are the law reform options. And I have here from Christopher Slogan's paper, and Eleanor made this available to you, and he gave his email address if you want to talk to him about this, you're more than welcome to. And he suggested that to address the underlying discrimination, what we can do is we can do away with the insanity defence and have a disability neutral defence such as that provided for in the American Model Penal Code. Okay? And that is, the language here is disability neutral, it's not linked to mental disability. So he suggests that's an option. Now, what he does say about that is that it's disability neutral, it will actually tighten the insanity defence in terms of the scope of the insanity defence. You do away with the insanity defence, this system based on excuse and justification. What happens here is that less people are able to avail of it, but it's compliant with the CRPD. And he says that he rejects this notion that you need the insanity defence to access treatment for a mental health problem. And so what he's proposing here is disability neutral. You can excuse behaviour, but less people can be excused in comparison to the insanity defence. I can pick up on that in questions and answers. In relation to unfitness to plead, I think what has to happen is that these laws have to be done away with. And what needs to happen in terms of state parties is that they have to support people to go through the court process. Okay? So you don't take people out permanently or indefinitely. What you do is you support them to go through the process and that they can face up to their criminal responsibility, and actually that way you avoid the human rights violation from coercion in the community, people in the community, or indefinite detention in psychiatric hospitals. I think that's quite important as well. The final point I will make in relation to this is going to be a challenge for Eleanor in this project, is achieving law reform in this area. Think about it. We've had the Regulation Units, the Ireland Act from 1871. There's been a huge struggle to try and change that at all. Now we've got some better legislation, still not compliant with the Convention. It's going to be very difficult to change the law in this area because there's going to be pushback, because these people who are going to who are dealt with by these type of areas, they've committed an offence or alleged to commit an offence. So it's very hard to change the law in this area. And that's illustrated by a report that was published by the Law Commission for England and Wales, which was published last month in January. And what they said here was that, in relation to the fitness to plead, that they recognise what the UN Convention says, but actually, do you know what, we don't really fully understand what that means yet, so we're going to comply with our domestic law and the European and our obligations under the European Convention on Human Rights. And actually, what they're going to do in England and Wales, if the Law Commission get their way, is that they're going to introduce for fitness to plead a type of functional assessment of capacity, which could potentially mean that a lot more people in England and Wales are deemed unfit to stand trial, which is a human rights concern. So that's really a snapshot of some of the issues. I don't have any more time to get into that. I have some references here for you as well if you want to read more on this. So thank you. I should also introduce our next speaker, who is John Kidney. And John is actually the most interesting profile I've read in this programme today, so very well done. John has a personal experience in mental distress, and he has a number of different hats, including he was very instrumental as an expert by experience on the recent expert group review of the Mental Health Act 2001. And John is going to talk about his own personal experiences. Okay. Thanks, John.
Well, this was a very personal view of the law and possible changes and all the rest. There was a character in a Dickens novel, I don't know which one, I think it was Bumble the Beetle, but his famous expression was, "The law's an ass." And in a lot of ways, I would agree with him. I think that we need laws, first of all. We need some social regulation. But a lot of the laws that we have are either protecting certain sections of society or enforcing a certain code of behaviour, which on kind of reflection can be a bit ridiculous. But just to give my own experience, which is kind of varied, as everything is in my life, I kind of had my teenage years, my 30s, when I became quite rebellious. Now, I know my mental health state had a lot to do with it. But I think, and by the way, could somebody tell me when 9 minutes are off? Okay. But I think a lot of my experiences were breaking social conventions rather than, I broke the law a lot of times. I committed one crime, basically, in my own view. And just to give you an outline of what I have done, is that I've trespassed on private property, because on a personal level I have very strong views on private property, and I was making a protest by actually reclaiming the spaces, as I say. I've also had a few social convention ones, like on another occasion, and this was inappropriate, I have to say, I became infatuated with a girl who was a lot younger than me, and I tried to, I was accused of harassment. I saw her only a few times, but I was obviously making a nuisance of myself. Now, if I was 20 years younger, it would have been totally ignored, but the fact that she was a lot younger than me, and I was making unwanted advances, meant that it was treated in a completely different way to a younger man. And you know, when you look at that, I know there are issues of responsibility involved, but anyway, I got a 7-month sentence for basically asking a girl out on 2 occasions. So it was using a sledgehammer to crack a nut, literally. These things are things which I think, as I say, under ordinary circumstances I would have done it, but I don't think it's a major crime in the canon of human history. I do know that there were issues involved which manifested themselves again later, because and these are kind of things which I've kind of I was very angry about this. On another occasion, a lot later, I was in a public park and it was a beautiful day, and I took off all the clothes and sunbathed. Well, that's all I did. But I was asked for my clothes by the park attendant, who was a woman, and I politely said, no, I'm fine. And I was arrested, and I was had up. Now it became a media storm down in my local area because they were all talking about pervert in the park and all that. I have no problems with nakedness. You know, I think the human body is something which is a wonderful thing, and there should be no shame about it. I think it was a reflection of as much of the hang-ups of society as any other personal issue that may have been involved. But having said that, I got 2 months sentence for that. But again, in all these cases, I defended myself, and maybe I didn't do a very good job. And equally, well, I didn't do a very good job. But I was also adamant that I be treated like anyone else. I didn't want any special treatment. I didn't want to be regarded as a medical case or to be diverted or anything. I wanted to be treated as an equal citizen. And I never brought up any medical defence in the issues. But I was very angry, and this is where I came out of prison and I was homeless, and I got a 2-month sentence for plus stripping off my kit. You know, it just reminds me of the Beatles song, I Am the Walrus, you know, pornographic priestess, oh, you've been a naughty girl, you let your knickers down, you know. Anyway, I got a 2-month sentence and I was very angry, and as a result of the refusal of a hospital to allow me to wash myself and to cook my food, I just told them, well, you know, when you make a genuine offer, I'm prepared to pay for this, but if you refuse, then there may be consequences. So I slashed tires. Anyway, that was a crime, and I was quite well aware that I was doing something wrong. But for me, I was making a protest, and I literally wanted to go to prison where I could study to be an artist. It all made sense to me at the time, but they had a wonderful, their shows, I have a lot to say about prisons as well, but I don't have enough time. They had a wonderful library in prison, which had all art books and everything, and kind of you know, historical journals and everything. And I'm sure there was no more interest to the average prisoner than what you might expect in I don't know, it's kind of totally inappropriate, but it was great for me. But anyway, these are all incidentals. I have a few proposals to make. I don't know, we're done for time now, but I have a few proposals to make. I think we should have social courts. I think we should have courts. If we have certain regulations that are we expect citizens to abide by, then I don't think they should be regarded as crimes. They should be social issues which are dealt with socially, and there should be criminal records involved in the situation. I do believe in criminal responsibility. I firmly believe that people know if they murder somebody that they're doing something wrong, even if they justify it in terms of doing a greater good. I think that anyone who has a mental incapacity, as they say, has the capacity to know that they are doing something wrong, legally wrong certainly, so they have legal capacity. I'm quite clear about that. I think that if we had a legal system that was operating properly and where prisons were humane places, I would think that there would be nothing wrong with ensuring that that people go through the courts, have legal capacity, and where needed and where it is acceptable to them, receive the treatment in prison which is humane and recognise their human rights. So there are the issues. That's my say.
Thanks, John. So it's my task now to try to respond to those brilliant presentations, to think about how we would approach these issues during our project. And I think the starting point is exactly what you said, John, that it's about equality and it's about equal rights and then equal responsibilities. And that's our starting point for all of these discussions. But I think you also raised some really important points about the flaws of the criminal justice system in general, and whether prison is a good place for anyone, and whether prison is achieving what prison is setting out to achieve, and whether people should have to go to prison to get the kind of support or to be able to try the kinds of things that they would like to do, like becoming an artist or learning a new skill or doing different things. Surely prison isn't the place that you would have to go in order to get that, and surely also the Central Mental Hospital shouldn't be the place that people would be sent in order to get support or think about living differently. I think from conversations I've had with a lot of people, this is a big problem, and I've also heard kind of another experience, which is that often when people are living in residential services and there might be an allegation of them doing something that might be criminal, for a long time those things wouldn't even be reported to the police. But when they have started to be reported, that they find nothing happens at all. If the perpetrator, the alleged perpetrator, is a person with a label or a diagnosis, that the TPP will often exercise their discretion not to prosecute. And that leaves everyone in really difficult situations, because not only does the person have an uncertain legal status and never has the chance maybe to clear their name about something that has been suggested that they have done, but also the services are left in a position of effectively imprisoning people and trying to, I know of situations where people have been accused of assaulting people of a particular gender or people of a particular age, and the service is then trying to keep them away from encountering anyone of that gender or age. And this is ridiculous that this is happening, but this is real and this is what is going on, and this is why we need to really rethink the law in this whole area. I think it's really important you brought up the issue of the blurred lines between morality and the law, and what's socially expected of people, and how people are even taught about what's socially accepted. And I think a lot of people who grew up in very segregated, institutionalized settings didn't have that opportunity to learn or be taught about what was considered social norms or social conventions, and then in order to break them. So I think that is a really important thing to consider. But it really, for me, comes back to the starting point of equality and the starting point of equal rights and equal responsibilities, and I think that's where we're going with this project. And we just need to figure out a better way to get to that end point of equality than what we have now. So I think I'll leave it at that.